for the appellant.
We'll take appearances, please.
May it please the Court. Counsel's name is Ms Watson, and today I appear for the appellant with my co-counsel, Mr Tizard. Today Mr Tizard and I will both speak for 18.5 minutes, leaving 3 minutes for a rebuttal, which we will split evenly.
Thank you. Respondents?
May it please the Court, Your Honours, I am Mr Zhang, spelt Z-H-A-N-G, and I appear with my learned junior, Mr Peake, spelt P-E-A-K-E, and we appear for the respondent, Mr Cotterill, in this matter. With Your Honours' permission, we will divide our time, allocating 20 minutes to myself, 19 minutes to my learned junior, and reserving 1 minute for our right of surrogate. May it please the Court.
Thank you. Are there any housekeeping matters, anything else that needs to be handed up before we hear from each side?
Yes, Your Honours, we have a series of bench books containing the extract of the cases that we will be referring to throughout the submissions. If you please the Court.
Thank you. I'll just say at the outset that I'm happy to look through them, but bear in mind that we're under some significant time constraints, but I'm sure you've taken that into consideration already. Getting ready. Yeah, Ms Watson.
May it please the Court. Today counsel for the appellant will argue two submissions. Firstly, that the full federal court erred in finding that the Minister's reasons for cancelling Mr Cotterill's visa were legally unreasonable. And secondly, that the full federal court erred in relying upon the case of MBNZ. At this stage, Your Honours, may we dispense with full case citations?
You may.
The crux of the argument for the appellant today is that the full federal court failed to regard the broad scope of the Minister's reasons, the Minister's discretionary power rather, in finding that his decision was legally unreasonable. On the objective facts considered by the Minister, counsel will argue that there was evident and intelligible justification for cancelling Mr Cotterill's visa. Beginning at submission 1.1, Your Honours. As the principles of legal reasonableness are central to this appeal, my submissions do begin by outlining these principles as they will be outlined today. However, if Your Honours are comfortable with these principles, I would like to move forward to the substantive issues on the appeal.
You can take it that we're aware of the broad brush principles at play, so if you can take to the substance and meat of your argument, so to speak.
Yes, Your Honour. Beginning at submission 1.2, Your Honours. The main argument for this submission is that the information considered by the Minister was sufficient for him to rationally conclude that Mr Cotterill's offending was serious, without being required to further investigate into the circumstances of the offending. At 1.2.1, it is accepted that the Minister made his decision to cancel Mr Cotterill's visa on limited information. However, Justice Wigney in Te Puke stated that part of the broad discretion of the power granted by Section 501, Subsection 2, means that it is within a Minister's discretion to choose the level of detail which they wish to receive in order to exercise their statutory power. I would contest my learned friend's submission, as stated at paragraph 11 of their written synopsis, that makes a distinction between the general comments relied upon by the Minister and the information specific to Mr Cotterill. Counsel for the appellant would submit that there is no reason why both general comments and the specific facts of this case cannot be used to justify the conclusion reached, especially in a case such as this, where the evidence available is limited.
But isn't that inherently your problem?
that the evidence available to the Minister didn't necessarily support the findings that he made?
My argument today, Your Honour, is that the information available to the Minister does support the findings that he made. At 1.2.2, Your Honours, the courts have stated numerous times, as found in the cases of Te Puke, Gobju and Hyun, that the Minister is not bound to consider the specific factors personal to the visa holder in every case. In the case of Hyun, Justices Kaifu and Bennett found that this proposition included the absence of an obligation to consider prior court material. In Hyun, a finding of legal invalidity could not be sustained merely because the Minister chose not to consider more than the fact that the respondent had been convicted of the offence.
Can I interrupt to ask, what in this case was the material that was before the Minister on this topic of the nature of the offending?
There are a number of matters before the Minister in this case, Your Honour. At paragraphs 10 to 20 of his reasons, he goes through these. However, I can summarise them for you briefly.
I'm sorry, paragraph 10 to 20 of whose reasons?
The Minister's reasons,
Right.
Your Honour.
And where are they located in the decision below?
Yes,
Do you have a paragraph for us?
may I take a moment to refer to my notes, Your Honour?
Of course.
Your Honours, the Minister's reasons are spread into course throughout the first 10 to 20 paragraphs of the decision below.
Thank you.
I cannot provide you a specific one.
So in summary, what's the answer to my question?
Could you please refresh me of your question, Your Honour?
What was the material before the Minister concerning the nature of the offending?
In this case, the Minister had access to the charging document, the offences that Mr Cotterill was charged with, the sentence that was proposed, and then the sentence that was reduced to when he pleaded guilty, the information provided by Mr Cotterill himself about the offending. There was also an issues paper. However, we accept, as our learned friends have stated, that the Minister did not explicitly consider that in his reasons.
But were there sentencing remarks or something like that?
No, Your Honour. In this case, as stated at paragraph 15 of the Minister's reasons, the sentencing remarks were unavailable, thus he could not consider them.
Thank you.
But in summary, there were 3 charges of indecent assault,
There
2
was,
charges of indecent dealing, all involving his own children, and all spent over a period of time,
yes, Your Honour. There were 5 overall convictions.
which he received sentences on each one of 12 months in prison.
The collective sentence, Your Honour,
Yeah.
was 12 months in prison.
And your submission is that's a sufficient basis to find that Mr Cotterill posed a serious risk to the Australian community?
The inferences that can be made from these findings, Your Honours, I would submit yes, is sufficient information for the Minister to find that the offending was serious.
If I understand your learned friend's argument correctly, though, are they not putting the case that the articulation of that connection wasn't sufficiently outlined in the Minister's reasons?
Yes, Your Honour, I would accept that that is their submission. However, I would like to remind the Court that when considering the Minister's reasons, they should be read broadly and without looking for error, and that we shouldn't be lost in the linguistic semantics of how they were stated. Rather, we should look at the overall feel of the reasons and the conclusion that the Minister reached.
But you accept that we can't read into those reasons what may not be there?
Yes, Your Honour, I do accept that. I would now like to address my learned friend's submission as stated at paragraph 11 of their synopsis, where they state that the circumstances of the offending were insufficient for the Minister to reach a reasonable conclusion. And I respectfully disagree with this conclusion, that the material available in this case does not convey the circumstances of the offending, and I'll consider that point in my next submission. And further, right now, Your Honours, it is my submission that any obligation on the Minister to consider in detail the specific personal circumstances of every visa applicant is narrowing the scope of their broad discretion and does not have to be done. In support of this principle, I refer again to the case of Hyun, where at paragraph 74, Justices Kaifu and Bennett found that because the general purpose of the Migration Act, it is impossible to look too closely into the factual circumstances of each visa holder, while still considering a matter as broad as the national interest of Australia. This is because some particular offences will command a cancellation of a visa because the offending is too serious, and any requirement to look into the personal circumstances of the visa holder would cut across the obligation to act in the best interests of the Australian community. And whilst at first instance this principle may seem overly prescriptive or predeterminative, Council would submit that it can be construed sufficiently narrowly to prevent its unreasonable extrapolation to offences that aren't serious in nature.
But didn't the full court in Stratton specifically say that that paragraph in Gwyn should be treated with extreme caution?
I'm not aware of that specific comment, Your Honour.
No thanks.
It says it's been adopted in Ostrom by at least 2 judges, 3 judges. High Court.
That would be a supporting point that I would adopt then, Your Honour. Additionally, I'd also like to point out that as a matter of policy, in the case of many offences, it could be useful to draw a line in the sand that would allow for a more uniform approach and that could prevent unreasonable decisions from occurring. Now moving to submission 1.2.3, Your Honours. My learned friends have argued that the Minister did not have any evidence of the offending circumstances, and Counsel for the Appellant disagrees with that submission. In this case, the facts about the offending, which can be determined from the factors considered by the Minister, as we've already referred to at paragraphs 10 to 20 of his reasons, and these factors can be summarised as follows. Firstly, that the offending is sexual in nature, and sexual offending is widely accepted as serious, both by the general public and by the criminal justice system, by reason of the fact that sexual offenders invade our personal sanctity in the most invasive way. Secondly, the offending was on minors, some of the most vulnerable members of our community. Thirdly, the sexual offending was a repeat offence. There were 5 convictions which Mr. Cotterill received. Fourthly, there is the potential that each of those convictions involved multiple occurrences of offending over a repeated period of time. And finally, the judge felt that the offending was serious enough to justify, but for Mr. Cotterill's guilty plea, a sentence of 2 years in prison. Accordingly, Your Honours, quite a significant amount of information about the circumstances of the offending can be determined based on the information which was available to the Minister.
Are we to take anything, if any, at all from the fact that a significant portion of that sentence was suspended?
Not in this case, Your Honour. Counsel would submit that the overall sentence still shows the seriousness of Mr. Cotterill's offending.
Might I say so with respect that your fundamental task is to show that there was an error on the part of the full court in reaching the conclusion it did. And to this point, I don't think I'm doing you a disservice in saying this. The focus of your submissions is really on the sort of argument you would run at first instance before a trial judge, and not focusing, as perhaps you should, more on the decision of the full court and the extent to which error is revealed in the court's reasoning. And the other point, perhaps while I'm interrupting you, is to say that these issues were only addressed by Justice North. Now, I appreciate there are constraints on what you have to deal with, namely the grounds that have been accepted as available grounds, but to me the most substantial issue, by a significant factor, is the reasoning of the 2 judges who addressed only one question, namely this question of whether there'd be permanent detention.
Yes, Your Honour, that issue will be dealt with by my co-counsel, Mr. Tizard.
Right.
It's not within my submissions.
Thank you.
In short, tell us why the court below needs to get rolled.
My submission, Your Honour, is that, as I stated at the beginning, they construed the Minister's power too narrowly. They stated that Justice North's main issue was that the Minister didn't have enough information to make a legally reasonable decision. What I'm trying to show to Your Honours right now is that on the information available, there was sufficient material there for the Minister to make a legally reasonable decision. Therefore, I would submit that the court above, the court below rather, construed that power too narrowly.
Do you cavil with the test that Justice North applied, or simply the conclusion he reached?
Sorry, Your Honour, I didn't quite hear that.
Do you cavil with the test of reasonableness that Justice North applied, or is your fundamental contention simply with the conclusion that he reached in applying that test?
Counsel has no issue with the test as stated by Lee, if that's what you are referring to, rather the conclusion reached by Justice North.
Do you place any reliance on the decision of Singh of the full court?
In regards to the principles of reasonableness, Your Honour,
And the requirement that those reasons be articulated, that rational basis be articulated in the reasons?
yes, I do accept that the justification for the Minister's conclusion does have to be found in the written reasons.
And your submission is that it was satisfied here?
Yes, Your Honour. There are two more points that I would like to make as to the seriousness as to why the factors support a conclusion of serious offending. The first of these is the requirement for Mr. Cotterill to be registered on the sex offenders list. And while I accept that that is a mandatory consideration for all a mandatory requirement for all sexual offenders, so it does not denote seriousness in that respect. Rather, when you consider it broadly among all offences, it does have connotations of seriousness, as there are a few other instances where the law requires that offenders released will have to report to the authorities for such an extended period of time. And this would be an indication of how seriously sexual offending is viewed, and that the public requires that sexual offenders be monitored once they leave prison. Additionally, I would like to contest my learned friend's contention at paragraph 12 that none of the information is sufficient to give rise to the circumstances that we have been discussing of the offending. The justification for this comes from paragraphs 17 and 18 of the Minister's reasons, where he reflects upon the length of sentence as imposed by the judge. And it's not a stretch of the imagination, Your Honours, to determine that a merry drunken flasher would not receive 2 years in prison for that offence. Thus, from what we can tell, the sentence that was initially handed down was one of 2 years in prison, and this would suggest that Mr. Cotterill's offending was towards the more serious end, rather than low. I would now like to move to submission 1.3, Your Honours, in regards to the risk of reoffending. At 1.3.1, Justice Wigney, in the case of Tapuki, stated that a minister is not bound to define the risk of harm in any particular way, or even to consider it at all. However, I do accept that as the minister has made a finding on this in this case, I do need to prove that it was a reasonable one. At 1.3.2, Your Honours, the most obvious factor which indicates that a visa holder represents an unacceptable risk is found within the scope of Section 501, Subsection 2, namely where the applicant in question has failed the character test. This is because it is implied by Section 501 that Parliament considers that any person who fails the character test would impose a risk of harm of some kind. Otherwise, there would be no justification for the minister being able to cancel a visa under the broader purpose of the Act. This proposition is supported by both Justices Rangier and Jessup in the case of Moana, with Justice Jessup stating that the discretionary power can still be validly exercised where, having considered the facts, the minister chooses not to take into account any consideration apart from the fact that the person in question was convicted of the offence.
If I may just pause you there, sorry to interrupt. My understanding of Moana is that Justice Jessup took a very different approach to the construction of Section 501 to that of Justice Rangier, in that he thought that the structure of the Migration Act in fact shouldn't be limited by its scope and purpose in the way that you seek to submit. So I don't quite understand why you seek to rely on that decision.
I seek to rely on the specific statements, Your Honour, of both sides of the bench rather in that decision. The other relevant principle that I would like to consider in regards to the risk of reoffending relies upon the case of Tapuki. Here, Justice Wigney found that once there is a risk of harm, the community should not be accepted to tolerate such a risk, especially where the result of another instance of offending would be one of serious harm. In Tapuki, the basis for concluding that there was a risk of serious harm in the future was on the justification that serious harm had occurred in the past. Thus, drawing on the principles taken from both statute and case law, Counsel would argue that the Minister's conclusion can be justified on the information available to him. The finding that Mr. Cotterill's offending is serious in nature and that he has failed the character test are two factors which initially support the conclusion that there is a risk of reoffending. And if we were to rely on Moana, they could be sufficient factors alone for that conclusion. In the interest of time, Your Honours, I'll move to my final submission at 1.4, where I argued that the specificity of the Minister's question with regards to the harm suffered by Mr. Cotterill's victims and the lack of specific evidence with regards to these individuals is not fatal to him reaching the legally reasonable conclusion that they did suffer serious harm. At 1.4.1, it is accepted by Council that the Minister did ask the specific question of whether or not harm occurred to Mr. Cotterill's victims. However, Council for the Appellant would submit that the narrow focus of Justice North on the phraseology of this question moves into looking for error rather than reading the reasons broadly. Your Honours, may I request a 2-minute extension to finish my point and conclude?
You may.
Thank you. Council would submit that in these circumstances, the Minister's conclusion that serious harm occurred, based on the general conclusion that sexual offending does cause serious harm, is sufficient to justify the conclusion reached. The end result in any case where a child is sexually offended by a parent is that serious harm will be suffered. And it seems contrary to conclude that could not be the case in these circumstances. It is accepted that there are no facts which substantiate this point. However, there are also no facts which support my learned friend's contention that serious harm did not occur.
Except the child's report to the Minister, which said to the effect that there was no harm suffered, and that she supported her father staying in the country.
That child in question, Your Honour, was not one of the children that was sexually offended by Mr. Cotterill. I would also submit that in a case where the offending has found to be serious, it is also likely that serious harm would result. And Mr. Cotterill himself made such a concession in the primary judge's decision, where he accepted that it was reasonable to assume that sexual offending of this nature by a parent would be harmful to the child in question. It is accepted that relying upon a generalisation is unusual. However, it is rare that there will be a case like this, where the offending was so long ago that determining the specific facts and harm that occurred proves difficult. Since the logical conclusion weighs in favour of the fact that harm is quite a serious possibility, Council would submit that the Minister could reach the legally reasonable decision upon those grounds alone. My time is up, Your Honours. Unless you have any further questions, that concludes my submissions.
Thank you, Ms. Watson.
Well, perhaps one before you sit down, or rather, these various criteria, they're derived from the authorities, I take it. They don't have any direct statutory foundation.
Which criteria are you referring
Well,
to, Your Honour?
the seriousness of the offending, the harm caused by the offending, and so on.
Those criteria emerge from the Minister's initial decision. He chose to base his decision on those 3 key factors. They're not found in any statute anywhere, no.
Oh, thank you.
Mr. Tizard.
The essence of the appellant's case on the second issue will be twofold. Firstly, the NBMZ was wrong to conclude that indefinite detention is an implicit consideration arising from the scope, subject or purpose of the Act, and secondly, in the alternative, that if NBMZ was correctly decided, there is nonetheless a worthy distinction between legal and practical catalysts leading to indefinite detention, and that on that basis NBMZ and Cotterill can be distinguished. Given that indefinite detention does not arise as an explicit consideration under the Act, the question or the issue that this appeal hinges on, is whether it can be read into the Act by implication, based on the appropriate construction of the scope, purpose and subject matter. NBMZ found that it was relevant. My submission is that it was not.
What do you have to satisfy us of before we can overturn NBMZ?
Simply that the decision was wrong.
Do you have an authority for that proposition?
Well, my submission is that the reasoning of Justice North was wrong. So, in essence, overturning it would involve agreeing that the process of legal reasoning was an error.
It's not only Justice North, it's the whole court.
Yes, Your Honour, correct. Broadly speaking, the purpose of the Act is to regulate in the national interest the intake and presence of non-citizens in Australia. And within the Act, Section 501 fulfills an important but narrow function regulating the intake of non-citizens, and its purpose, on my submission, is to ensure that those who do gain entry do so lawfully and are of a suitable character. To that end, Section 501 subsection 6 includes a character test which has a number of elements. All of the elements of that character test relate in one way or another to preserving safety and security within Australia. In essence, it is a filtering mechanism focused not on the consequences of visa refusal, but on the character of the applicant or the entrant. And it is focused on ensuring that the intake of non-citizens is in the national interest and would not detract from the safety or security of Australians.
But the court in NBMZ cast that slightly differently, don't they? They rely on the statement, and I note that your learned friends also rely on this statement, to the effect that the purpose of the Migration Act is not simply cast as narrowly as you say it is, but also to regulate the presence in Australia of non-citizens, one consequence of which is the presence in Australia, whether that be in detention or otherwise.
Yes, right. I would accept that the purpose of the Act is broader than that, but within the Act, Section 501 has a rather narrow purpose, and that purpose, on my submission, is to regulate the intake of non-citizens to ensure that they are of a suitable character.
But you don't look at the scope, nature and purpose of the section in an Act, you look at the Act as a whole, don't you?
Yes, Your Honour, yes. Well, insofar as the purpose of the Act as a whole is concerned, the Act has multiple different purposes, but Section 501, narrowing in on that section, gives effect to the national interest by ensuring that those gaining entry are of a suitable character. And that is the particular purpose of the Act which I rely on, and I think that's a sufficiently broad interpretation of the Act for these purposes.
Do you recall whether there's any a provision in the Migration Act that requires the Minister to remove someone who's not lawfully in Australia?
Yes, Your Honour, that's the visa scheme is central to that, because without a visa, they're not a lawful citizen. There's a strict binary, lawful and unlawful citizens. Without non-citizens, without a visa, they're an unlawful non-citizen.
Well, doesn't it follow that once the visa is cancelled, as it was in this case, then the Minister's under an obligation to remove the individual whose visa has been cancelled? And that can be taken to indicate one of the purposes of the Act is to ensure that people without visas leave Australia. And wouldn't it follow that if in a case such as this, if it be the fact that the individual concerned can't be removed, then that to some extent is inconsistent with those fundamental purposes of the Act?
Potentially, Your Honour, that is one way of looking at it. My submission is that there are different steps in the administration scheme, and this step is narrowly focused on determining whether the non-citizen is of a suitable character to seek entry. If they're not, then the consequences will flow, and that is a separate question. But if you'll allow me to return to my submissions, I think if I develop this point a little bit further, it might assist with answering that question.
Certainly.
When considering a matter as broad as the national interest, my submission is that it would be an awkward requirement for the Minister to then consider something as narrowly focused and as tangential to the issue of character as the consequences for an individual, the consequences of visa refusal. And I gain support for this submission from the case of Hai Yun at paragraph 71, where Justices Kaifel and Bennett note that the personal circumstances of the applicant are not relevant in determining whether a visa should be granted or refused. And at paragraph 76, they go on to state, it is for the Minister to determine, in the exercise of the discretion given by the section, whether they assume importance in a particular case. And so, Your Honour, in answer to your earlier question, the modest submission for the appellant is not that indefinite detention is never relevant. Rather, it is that it is not for the court to determine in a broad sweep that indefinite detention will always be relevant. Because my submission is that that would cut across the broad discretion afforded to the Minister. Does that answer Your Honour's question?
Is that necessarily a bad thing, though?
Well, it is when you consider the parliamentary intention behind affording that discretion. And in my submission, subsections 1 and 2 are designed to give the Minister discretion in order to consider residual matters which relate to an individual's character. Because subsection 6 can only foresee so many matters that relate to character. And so subsection 1 and 2 allow the Minister some broad discretion in order to consider matters still relevant to character that can't be foreseen by subsection 6.
And he doesn't have to consider, well, he or she doesn't have to consider the consequences of the exercise of that power in your submission.
That's correct, Your Honour. And in fact,
Mr. Tiller, neither you nor your co-counsel cite Nystrom, in which the whole of the court, the High Court, this court, don't worry about the federal court, this court's here to overrule the federal court if it thinks it's wrong. This court has endorsed the passage in Iron that you just, or appears to have, that you just read out. So that's the more important reference, paragraph 126 of Nystrom.
Yes, you're quite right, Your Honour. That is precisely the point. And in fact, I'll get to this slightly later, but there's a good policy reason for overturning this decision in MBMZ, and that's because it opens up a huge can of worms where the Minister would be required to consider personal circumstances of all natures, not just relating to the consequence of visa refusal, but all types of personal circumstances. So effectively, you would be overruling the long line of authority, including Nystrom, Jallik, and Hai Yun. So the implications would be broader than just visa refusals.
What's your understanding of the finding, if that's the right word, of the full court in this case, about why this gentleman wouldn't be able to return to the UK? Was it that he was too sufficiently unwell not to be able to travel, or that he wouldn't be allowed entry into the UK, or what?
Well, Your Honour, that's a good question. Unfortunately, I can't assist greatly on that matter because the facts simply don't afford a detailed understanding, but it is referred to as a possibility. I'm willing to accept that Mr. Cotterill is entitled to have this appeal decided on the assumption that he cannot return, because any other submission would be speculative.
Yeah, it's only a possibility.
Well, yes, Your Honour, but speculative submissions have been roundly rejected before. In particular, in NBMZ, there was this hypothetical...
That's not this court.
No, certainly not, Your Honour, but to adopt their reasoning, which I would submit as sound, they found that a submission that was made for the Minister that there could be potentially a third country which he could be removed to was speculative, and so he was entitled to have it decided on the assumption he couldn't be returned. There was no alternative location.
Yes, but in NBMZ that consequence was specifically authorised by Alcatab, was it not?
Yes.
The individual in the case of NBMZ was an Iranian national, and Iran was refusing to accept his return.
Yes.
So the consequence of indefinite detention was authorised by the Act. Is that not the same problem that you face here?
Well, not necessarily. And I think this relates to a broader point, and that is that a lot of my learned friends' submissions are predicated on this view of the Act, that the Act somehow causes or provides for indefinite detention. that, in my submission, is a mischaracterisation. The Act does no such thing. The Act makes it a possibility. The Act lays the foundation, lays the groundwork, but the ultimate cause of indefinite detention is an independent force outside the Act. In particular, Mr. Cotterill's health issues, in NBMZ, the Convention on the Status of Refugees. But in both of those cases, they are independent actions, they're independent forces outside of the Act. And so the Act, in no sense, causes indefinite detention, although it does allow for the possibility.
Well, in fact, it mandates that possibility, does it not, in sections 189 and 192, which read together say that any unlawful non-citizen without a visa in Australia must be detained until such time as they can be reasonably removed.
Yes, John, that's right.
So how is that not inherently a consequence of the Act?
Well, that is my submission. It is a consequence of the Act, but the Act doesn't cause indefinite detention, because in this case, if Mr. Cotterill was of good health, there would be no problem removing him. And so it's simply a matter of looking at what the real catalyst is. But I think to get back to the real question, the question is, does indefinite detention arise by implication from the statute? And in my submission, it would be a very awkward and uncomfortable requirement to place on the minister that indefinite detention is always a relevant consideration. And in my submission, it would take the Section 501 assessment off course at a very uncomfortable tangent, requiring him to consider things like the consequences of his decision to refuse a visa. And that, I think, is an important point, because if my learned friends seek to submit that the minister is obliged to grant visas merely because the consequence of not doing so is indefinite detention, then the minister is inclined to cut against the purpose of the Act, which is to protect the safety and security of Australians, and potentially grant visas merely because the consequence of not doing so is indefinite detention. And that could create a distortion, which in fact is outlined at submission 218.
Before you go any further, Mr. Teaser, do you place any reliance upon the comments of both the plurality and Justice Buchanan in the full court in MDMZ of the human consequences or the inherently human nature of the effect of termination under 501?
Yes, Your Honour. I think it would be a particularly unattractive submission to say that they're completely irrelevant, because clearly they're severe. The submission for the appellant is that they can easily be softened or ameliorated through a residence determination under Section 197A D, or D, I think it is. Yes. But strictly speaking, although I accept this as an unattractive submission, strictly speaking, the consequences
You
are...
should make that concession before you make the submission, if I might say so.
Thank you, Your Honour. The real issue is the character of the applicant, and indefinite detention does not relate to character. That is the core submission for the appellant.
On that point then, that seems like a good moment to move to paragraph 2.2 of your submissions about whether MBMZ can be distinguished here.
Yes, Your Honour, but would you permit me to make 2 points in passing just in relation to my learned friend's submissions?
Certainly.
The first is in relation to their attempt to distinguish Hayun, which on my submission is bound to fail, because Hayun deals with the same section as the present case, and the case they suggest in the alternative does not. That is Plaintiff S4. But the more important point is that that case actually stands for the proposition that the minister cannot stall his consideration and create a situation where definite detention arises merely due to the fact that he is waiting to consider whether to grant an order under Section 46, which is an entirely different section from the present case. And the second point in passing is in relation to my learned friend's submission at paragraph 20, where the key link in that chain is that indefinite detention is an impediment to the minister's exercise of regulating the intake and presence of non-citizens. In my submission, indefinite detention is not presence in Australia in any meaningful sense of the word. indefinite detention, if you'll permit a grim analogy, is really the coffin on the way to the grave. There's no escape from indefinite detention, and so there's no basis to say that the minister's impeded by the impossibility of removing a non-citizen. That would be my response to Learned Friend's submission at paragraph 20. Turning to the second aspect of the appeal then, the submission is that if NBMZ was correctly decided, it still matters that the catalyst in that case was a legal factor, namely the convention, as opposed to a practical factor. And to clarify, this is the only basis on which the appellant wishes to distinguish the two cases. There doesn't seem to be much gained from responding to my learned friend's submissions at, I think, paragraphs, or whichever paragraphs relate to the minister's absence of the issues paper mentioning it. There doesn't seem to be any benefit in considering that. The appellant's reliance is placed entirely on this distinction between legal and practical consequences, and I submit there are 3 reasons to uphold that distinction. Firstly,
Before you move into that more detail, what is the, broadly speaking, the distinction between legal and practical consequences? I must say it's not obvious to me that it's as sort of a bifurcated choice between one or the other.
yes, Your Honour, that is one of the difficulties I would have to concede with this submission. It's not easy to draw the distinction, but respectfully, my learned friends, would you permit just a 2-minute extension?
Yeah,
I think he has 5 minutes
There's 5 minutes. 3 minutes. You've got 3 minutes. So.
Thank you. The distinction is, when you look at the cause of indefinite detention, in the present case, the cause is Mr. Cottle's health issues. But for those health issues, there would be no difficulty removing him. In NBMZ, the difficulty arose as a legal matter due to the non-refoulement obligations under Article 33. That's the distinction.
And why do you submit that we should uphold that distinction?
Yes, Your Honour. So, turning to the first of those reasons. Firstly, when indefinite detention arises from the interaction of laws, it is a certainty. It's foreseeable and it's certain. But when it arises as a consequence of a practical catalyst, the consequence is far from certain. And I didn't wish to argue the point any further which Your Honour's raised, that in this case it's a possibility, because in fact that reinforces this distinction which I would like to draw. And that is, in the present case, although Mr. Cottle is entitled to the presumption that he cannot be removed, it is far from a certainty. There is the possibility that he could be removed, and the issues paper only referred to a possibility. And in other cases, it may be even less certain than here. It may be less certain that those practical circumstances won't change, and that indefinite detention is not indefinite after all, and that it does become possible at some point in the future. The second reason is that upholding a distinction between practical and legal catalysts invites those seeking entry into Australia to manipulate their circumstances in order to make it more difficult for the state to remove them. And essentially, just to simplify that submission, my contention is that allowing the minister to, or requiring the minister to consider indefinite detention where it arises from practical circumstances would incentivise devious entry tactics. And a hypothetical situation could arise, I'm not suggesting this is legally obvious, but there could be a situation where an unlawful entrant seeking refuge under the Convention declines to apply for a renewal of a visa in a third, less preferable country, winds up in Australia and with no alternative destination and applies for a visa, in the hope that the minister will relent, consider indefinite detention, grant him a visa. That's the submission under that point. The last policy reason is that which I mentioned earlier, is that it would open up that line of authority in relation to the courts considering the personal circumstances. Based on those three reasons, Council submits there is a good reason to uphold that distinction, and that distinguishes this case from NBMZ. Thank you, Your Honours.
Thank you. Mr. Zhang.
Can I just get the spelling of your name?
Yes, Your Honour. Z-H-A-N-G.
Z-H...
A-N-G.
Sorry.
When you're ready.
May it please the Court, Your Honours, we have two submissions in relation to this appeal. First, that the Court below did not err in finding that the Minister's conclusions lacked an evident and intelligible justification insofar as such a finding was made. And second, that the Court below did not err in relying upon the case of NBMZ. I will be addressing the first ground of appeal relating to the unreasonableness of the Minister's decision. And it is our submission, Your Honours, that each of the conclusions made by the Minister lacked an evident and intelligible justification, and by reason of these conclusions being crucial or integral to the Minister's final decision, that the final decision was rendered unreasonable. Before we address each of these conclusions, however, Your Honours, it is necessary to establish the correct nature of the inquiry that the Court is undertaking when a court is considering a Minister's reasons given for the decision. The correct inquiry is not to simply consider whether some line of reasoning and conclusion would have been open to the Minister under their broad discretion, but rather whether the conclusion was open to the Minister on the explanation and reasoning process as outlined within their reasons.
I think that was accepted by your learned friends. I think you can move on.
Yes, Your Honour. If Your Honours are content to accept that, then I turn to the first conclusion, that regarding the finding that the respondent's offending was serious. Our learned friends have contended that the conclusion of seriousness from the offences considered objectively was justified, and that in any event the Minister was free to decide what degree of information or what detail about the circumstances of offending they wish to receive. We acknowledge that certainly it is within the Minister's scope of their broad discretion to determine that level of detail. However, we submit that the bare charges and sentences could not provide a justification for two reasons. First is that the Minister, in fact, chose a level of detail that went towards the particular circumstances of offending in reaching his conclusion, as opposed to some level of generality that would have been sufficiently expressed by the sentences and bare charges. And second, that the sentences and bare charges say nothing about these actual circumstances.
I'm sorry, are you accepting that this aspect of the decision-making could have been approached by the Minister on the basis that he or she could simply have regard to the nature of the charge that's been brought and the crime of which the person's been convicted?
That's correct, Your Honour. Due to the broad nature of the discretion conferred under Section 501(2), it would certainly be open on a point where reasonable minds may differ that the sentence alone might indicate sufficient seriousness about the degree of offending in all circumstances. However, with the focus of the inquiry being the intelligent justification as arising from the reasons that the Minister actually gave and that the Minister actually followed, we submit that this is not the process of reasoning that the Minister applied.
But it's only a very short step, is it not? I mean, I know that your learned friends rely on the case of Tapuke. The full court in the case of Rosner also said effectively that the bare facts are enough to support a finding of seriousness without any further inquiry, is it not a very short step to say that a bare charge is also enough?
Ordinarily, Your Honours, we accept that it might be a short step. However, in this case, where the Minister did make the decision to accept the detail of information going towards the circumstances of offending, and where that information about those circumstances suggested against seriousness, then that is where the lack of evident or intelligible justification lies. No.
Is your submission that the material before the Minister provided no basis for a finding of seriousness?
That's correct, Your Honours. First, that the nature of the inquiry, Your Honours, was that the Minister chose to ask about the seriousness of the circumstances of offending, and that it follows that it is not possible to come to a rational conclusion about the seriousness of those circumstances unless there are, in fact, some circumstances that demonstrate that.
Such as a charge of indecent assault on a child?
Your Honours, it is our submission that the Minister didn't apply that general level of reasoning. Nowhere expressly in the reasons does the Minister state that it is on the basis of the charges being applicable in such a general nature that the specific circumstances of the respondent's offending were serious.
I think that's a very good concession you've made. I happen to agree with you, but what can you help us? What's the where you say he descended into particularity and it's part of his reasoning process? Can you help me with what part of his reasoning process you're referring to?
Yes, Your Honour.
Passage from it, or
If I may take you to our bench books at tab 1, labelled as Respondent Senior Counsel, to the case of Cotterill extracted in the court below.
paragraph?
At page 620, in paragraph 12, where it illustrates paragraphs 15 and 16 of the Minister's reasons. Here, Your Honours, this demonstrates where the Minister elected to go beyond the mere general statement of the bare charges and look to the particular circumstances of the respondent's offending and the material that the respondent had submitted to him in this regard.
But is the Minister not entitled, and I think Tapuke says about as much, to look at those facts and draw a conclusion that those circumstances were in fact serious?
That's correct, Your Honour. However, Tapuke was concerned with the distinguishment or the difference in the view that the Minister came to as opposed to the sentencing judge's remarks. Yes.
Rosner was a case that dealt with the sentencing judge's remarks and said the same as Tapuke did.
That's correct, Your Honour. However, in both those cases, there was a wealth of other objective facts about the circumstances of the offending which the Minister could refer to. If I may...
There he's setting out what is said by Mr. Cotterill and some family members about the offending, but it's very clear that he doesn't accept that. If you go down into the next paragraph, paragraph 13, he sets out several paragraphs in the Minister's reasoning, and the Minister says in paragraph 19 of his reasoning, I note the information Mr. Cotterill provided regarding the circumstances of sexual offending. I adopt the judicial finding. That is one of guilt.
Yes, Your
Not
Honour.
a trumped up charge, isn't it?
Your-
Fabricated, but one of guilt. And the man had pleaded guilty to them anyway.
Yes, Your Honour. However,
So
it is precisely our submission that, well, first, Your Honours, we note that the Minister did not note a finding as to that evidence before him about whether the offences were fabricated. And on one hand, it is our submission that without coming to that finding, the Minister could not have actually concluded about the actual seriousness.
It's an ineluctable conclusion that he accepted the judicial finding, he accepted the finding of guilt. The man was guilty of these offences.
Yes, Your Honour, and it is precisely that conclusion, drawn solely on the judicial conclusion of guilt, that we submit gives rise to the unreasonableness in reaching this conclusion. If I may take Your Honours to the case of Tapuke at tab 15 of our bench book, perhaps to illustrate the distinction that we seek to draw.
That's not a complete extract of Tapuke, is it, that you've provided?
No, Your Honours. At page 520, I withdraw it, Your Honours, at page 505, paragraph 24. There, the court extracted the Minister's reasons as set out, which refer to various detailed circumstances of the particular offending. It was in the presence of these other circumstances or information and objective facts that the court in Te Puke held that the minister was entitled to form their own view of the seriousness of those circumstances, notwithstanding the sentencing judge's remarks.
If I may take you to paragraph 97 of Te Puke, which I'm not entirely sure is included in your extract. Justice Wigney specifically states that the sentencing judge's findings or opinions about certain matters relating to the seriousness of the offence are specific factors that the minister could, and this is the part that I emphasise, but was not obliged to have regard to. Do you submit that we should reverse that finding in Te Puke as well?
No, Your Honours. It is not our submission that the minister ought to be obliged to consider particular factors, but that by reason of inclusion of those circumstances, namely the material that suggested the fabrication of those offences, or at least that they weren't justified by the convictions, that the minister considered it material. And on that proposition, Your Honours, we rely upon the case of the decision of this court in Yusuf, in that all the matters listed out in the reasons are to demonstrate to any person with certainty what matters the decision maker found to be material in reaching their conclusion. And it is on that basis, Your Honours, that if these circumstances were material, as is illustrated by the fact of them being in those reasons, then without coming to first a finding on whether they accepted or rejected that evidence, then the minister could not rationally come to the conclusion that he did about the circumstances of offending simply on the general nature of the offences and sentences alone. If Your Honours have no further questions on that submission, then I turn to the second conclusion regarding the risk of reoffending. Our learned friends have submitted that the minister was entitled to conclude that there was a risk of reoffending just by virtue of the serious nature of the harm, or of the offence, and the serious harm caused. And once again, Your Honours, we acknowledge that this certainly might have been a line of reasoning open to the minister. However, once again, the reasons of the minister do not disclose that as part of the reasons. And on the authority of Singh, the intelligible justification must lie within those reasons. It is our submission, Your Honours, that the reasons of the minister did not contain such a presumption on two bases. First, the lack of referral to that presumption expressly in anywhere in the minister's reasons. And second, that if we were to take our learned friend's submission as highest, then the only source for such a presumption would be from the issues papers matters. Whilst we note that our learned friends have not sought to rely upon this or incorporate this, it is our submission that if that were to be the prospective source of that matter, then it was nonetheless not part of the reasons.
Despite the fact that paragraph 8 of the minister's reasons, which were extracted at paragraph 49 of the decision below, he specifically states that I've assessed the information set out in the issues paper.
That's correct, Your Honours. In doing so, we seek to draw a distinction between whether a minister may have considered or read or assessed particular matters and whether they find it material. We once again highlight the authority of Yusuf, which is that the content of the reasons is what demonstrates to any person with certainty what matters the minister considered to be material to their decision. And the absent, yes.
Sorry, I just wanted to draw your attention to both cases of Gabouge and MZAGK, both of which dealt with similar statements to that of paragraph 8, and in both cases the court held that the issues paper was in fact incorporated into the minister's reasons.
With respect, Your Honour, in the case of Gabouge, the finding by the court was not that the issues paper or departmental submissions, as it were in that case, were incorporated as part of the minister's reasons.
Or at least that he had regard to those factors.
That's correct, Your Honour. Relevantly, Your Honour, the issue before the court in Gabouge was whether the minister had failed to take into account a relevant consideration. And perhaps to illustrate this distinction, if I may take Your Honours to the case of Gabouge at tab 11 of our bench book. Extracted at page 10, at paragraphs 19 and 20, respectively. There, Your Honours, the court held that while the decision maker had clearly considered the departmental submissions, the failure to mention the actual matter demonstrated that the minister ascribed little or no importance to them, and as such there was no finding that the issues paper there formed part of their reasons. We seek to draw the same distinction in this case, Your Honours, that this amounts at its best, as far as the issues of unreasonableness are concerned, to a consideration of those issues, and not to an adoption or to a reliance or finding of them as material. And on that basis, Your Honours, we submit that there is no source in the reasons for any presumption by the Minister that the mere fact of the offence itself led to a risk of reoffending presumption. And through the lack of that presumption, there is no rational or evident or intelligible justification for the Minister's conclusion in finding that there was in fact a risk of reoffending. If
Can
Your
the
Honour-
Minister not form that view simply by virtue of the fact that it's happened in the past?
Your Honours, yes, we don't contend that the Minister, that it was not open to the Minister to form that view. Certainly the broad discretion and nature of the power under Section 5012 seems to support that. However, once again, the inquiry must be on the intelligent justification as it lies from the reasons. And it is our submission that, as we've illustrated, that such a presumption was neither in the reasons expressly, nor could it be incorporated from the issues paper. And the absence of this from the reasons demonstrates that the Minister did not find it material. And in the absence of such a presumption, there could be no evident or intelligible justification for the conclusion that he ultimately arrived at.
So you say that's something that the Minister could have done but didn't cross the I's or cross the T's and dot the I's, so to speak.
Certainly, Your Honour. If Your Honours have no further questions in relation to the second conclusion, then I turn now to the third conclusion regarding the finding by the Minister that the offences had caused serious harm to the victims. Our learned friends submit that it is in the nature of such offences that harm will be caused, consistent with the trial judge's reasoning at first instance on this matter, and seek to draw no distinction between this and the specific harm actually suffered. With respect to our learned friends, the general proposition first holds no application to a specific finding as found by the Minister of the actual harms in fact suffered, and in any event was not the line of reasoning adopted by the Minister. The only reference, Your Honours, that the Minister makes to this conclusion of suffered serious harm is at paragraph, extracted at paragraph 7 of the judgment in the court below, where he states that Mr. Cotterill's offending has caused his victims to suffer serious harm. This is a finding specific to the actual harm suffered, and the reasons make no reference to the application of some general presumption that harm was suffered constructively by reason of the general nature of these offences resulting in harm. And once again, as the justification must lie within the reasons provided by the Minister, that the justification contended by the appellants is not applicable to this decision, or this set of reasons which the court is examining.
Is the Minister not entitled to take that as, whether it's this or not, as axiomatic and as almost to the obvious to the extent they go without saying?
Your Honours, certainly it is. However, the material difference is the exclusion of any application of that kind of general reasoning which our learned friends seek to rely upon.
But doesn't Tapuke paragraph 86 permit that exclusion? It permits reasoning by generalisation in these circumstances?
That's correct, Your Honour. However, in Tapuke, the Minister did in fact rely on some other source, as opposed to, in opposition to the sentencing judge's remarks.
But so your submission is effectively that the Minister can't infer that sexual offences against children cause harm to those children?
No, Your Honour. The Minister is perfectly entitled to make that inference.
And is entitled to reason by generality to Mr. Cotterill's case, as
No.
Tapuke says?
That's correct, Your Honour. It is simply our submission that in this instance he did not do so.
Your attack on all grounds is the process.
That's correct, Your Honours. Due to the nature of Section 5012, the area of decisional freedom which the Minister has is broad, and there are a wide range of outcomes on which reasonable minds may differ, which offer no ground of judicial review. However, the ground of review or the basis of review here must arise from the reasons themselves, and is a question of whether, in the reasoning process actually applied by the Minister, whether they had an evident or intelligible justification.
SING also permits us to make a inference, though, from the outcome that the Minister reached, though, does it not? It's the second limb, effectively, that the full court found in that case. Why can we not infer from the finding that serious harm was suffered that the Minister assumed that serious harm to children, particularly these children, was suffered? Why is that not a rational finding for this court to make?
Your Honours, in response to that, we highlight again the presumption that arises from USIF, namely that the purpose of the reasons is to demonstrate with certainty the matters that the minister considered material in exercising their discretion, and in turn, the inference that is open to the court is in the absence of those matters that the minister did not find those to be material. Given that the only guiding statement we have from the minister is that the offences in fact caused the respondent's victims to suffer serious harm, and not any application of some general process of reasoning or inference, then that indicates, Your Honours, to this court that that was not a material basis of the minister's reasoning. If Your Honours are content on that point, then by reason of the lack of any factual basis of serious harm or any harm actually suffered by the victims, that is common ground on this appeal, then we submit that the minister's third finding also lacked an evident and intelligible justification.
I thought you accepted a few minutes ago that the nature of the offence itself could be sufficient to justify a conclusion that serious harm was caused.
That's correct, Your Honour.
So you accept that, but you're saying in this case, for some reason that I presently don't understand, some additional material needed to be before the minister before he reached the conclusion he did?
Yes, Your Honour, and that is because of the different inquiry that the minister has come to in his conclusion. We highlight again that the conclusion that the minister drew was not one of general application or inference, but whether the respondent's victims had in fact suffered serious harm. It naturally...
But you also accepted my submission, or my proposition, that Te Puke permits the minister to take the assumption based on the type of reasoning, based on the type of offence, and apply that to the circumstances of Mr. Cotterill.
Yes,
How
Your
do you
Honour.
accept both of those propositions and get to the conclusion that you're trying to put to us?
Your Honours, I note that my time has expired. If I may have a brief extension to address this question.
Right.
Both of those propositions, Your Honours, go to a matter of what the minister may be entitled to do, not a matter of what the minister has in fact in his process of reasoning concluded here. If Your Honours accept that the inquiry the minister has conducted here is into the actual harm suffered by the victims, as opposed to some presumption or inference, then it follows naturally that what is required to have any rational basis for that conclusion is to have some evidence of actual harm suffered in fact. And it is our submission that in the absence of any factual basis for that finding, then the conclusion in turn lacks an evident and intelligible justification.
Fine distinction, but I understand.
Thank you, Your Honours. If Your Honours have no further questions, may it please the court, those are our submissions.
Thank you. Mr. Peake, when you're ready.
May it please the court. Your Honours, the key question in relation to the second ground of appeal is whether or not the prospect of indefinite detention is a relevant consideration for the minister to take into account when exercising the visa cancellation power in section 501 subsection 2 of the Migration Act. I'll be making two submissions as to why the full court of the Federal Court did not err in relying on the case of NBMZ and Minister for Immigration. First, because that decision was correctly decided in holding that the legal consequence of indefinite detention was a relevant consideration, and secondly, because that distinction is not distinguishable from the present case. In response, before progressing to those submissions, firstly, Your Honours, to the question that was put to my learned friend about what it would take for this court to find that the full court of the Federal Court erred in relying on the case of NBMZ, owing to the fact that the full court was obliged, bound, to follow the decision of another intermediate appellate court, unless that decision was plainly wrong, under the authority of this court in Farah and Sadie, it follows that this court must find the decision in NBMZ was plainly wrong before there can have been a legal error on the part of the court below in relying upon its principle.
Though we can also accept that NBMZ may have been superseded by developments, other circumstances, etc. as well.
Indeed, Your Honour.
But it also suggested the High Court at that time didn't like the New South Wales Court of Appeal at that time.
That's correct, Your Honour, but it is far from certain what its disposition is towards the full Federal Court on matters such as these either. Turning to the first submission, the classic test for whether or not a relevant consideration exists in the exercise of a statutory power was supplied by this court in the case of Pico Walsend. Where there are no express considerations contained within the provision, This ground of review will not be made out unless it is available by implication from the subject matter, scope and purpose of the Act. In the case of Shawn Investments and McKellar Proprietary Limited, in the judgment of Justice Dean, it was held that in the case of an unconfined discretion, which Section 501(2) is, it is generally for the decision maker to decide, in the circumstances, what are the relevant considerations and the weight to be ascribed to each. The rationale, as His Honour put it, for that principle was that an applicant for judicial review ought not be entitled to assemble a list of all the matters which a decision maker might conceivably regard as relevant, and then attack the decision on the basis that a particular one of them was not taken into account.
I want to jump in here and put this to you. That passage you just read says that it's for the minister where you've got a broad discretion, such as we have here, to identify the matters that are material to his decision. And here, one of the matters he's identified clearly are the personal consequences to the detainee of having his visa cancelled.
Indeed, Your Honour. However, of the potentially relevant personal circumstances or other matters which the Minister might decide to have regard and might decide to attach some materiality, the one that he didn't take into account was the prospect or the consequence of indefinite detention. The only basis on which that can be a relevant consideration is if that consequence was, or can be, implied as one that the statute mandated in these circumstances the decision maker to take into account.
But it would be irrational, wouldn't it, to take into account the difficulties this man might face in adjusting to life back in Britain with all his health problems, and yet ignore the fact that he might be stuck in indefinite detention or detention for some indeterminate period of time.
I'm inclined to agree with Your Honour to the extent that the factual circumstances which led the Minister to consider the impediments upon removal, if indeed Mr Cotterill made it back to the United Kingdom, on that basis it's a small step to hold that the impediments to removal were also relevant considerations. However, I raised Justice Dean's passage because His Honour cautions that the starting where the relevant consideration originates from is not the factual circumstances. It originates from the Act. It is in the circumstances that the Act mandates it be taken into account, but we have to find this relevant consideration in the subject matter, scope and purpose under which Section 501 is conferred. Our learned friends on that front have advanced two main submissions. First, that there's nothing in...
Well, let's put to one side what they've said. What do you say?
That there are two main constructional indicators which suggest that which support the implication that the legal consequence of indefinite detention is a relevant consideration. The first and controlling one we submit is the legislative context in which the visa cancellation power exists. That is the effect on this power and of this power on other provisions in the Migration Act. The second basis on which we say there's a strong constructional support for the existence of this relevant consideration is the purpose and object of the Act, as stated in Section 4, Subsection 1, which is to regulate in the national interest the coming into and presence in Australia of non-citizens. With respect to the first of these, Your Honours, the legal consequence of indefinite detention arises because of other obligations imposed upon the Minister under the Act. The purpose of the Act is that broad regulatory one. It is to decide in the national interest which non-citizens may remain on Australian shores. That regulatory purpose is achieved by the successive or sequential operation of a number of provisions of the Act, and not simply Section 501. Upon cancelling a visa under this section, the person becomes an unlawful non-citizen. At that point, the Act mandates in Section 198, Subsection 2, that an officer of the Department, of the Minister's Department, remove that person from Australia as soon as reasonably practicable. This court, in the case of Plaintiff M76, stipulated that removal means removal to a place. A non-citizen cannot be removed from Australia unless they'll be received at the place to which they are taken.
This court in M68 though also said that effectively that question of removal and acceptance is outside the scope of this court to supervise, did it not?
No, Your Honour. Only to the extent of Section 196 of the Act. After the removal obligation is attracted, if that's not reasonably practicable, in the meantime the person must be detained under Section 189. Now the court in Plaintiff M60 and also earlier in Alcatel and Godwin looked at that detention, this will become relevant to our second submission, looked at that detention and said that Section 196 of the Act stipulates 3 and only 3 terminating events, one of which is that a person is granted a visa, another of which is that a third country agrees to take a person, basically that they're removed from Australia. And so, Your Honours, the impracticability owing to Mr Cotterill's ill health of removing him from Australia directly affected the capacity of the Minister to discharge his obligation, the obligation of his department, under Section 198.
But what is it about the words of 501 that mean that we have to take those into account?
Your Honour, it is precisely outside the words of 501 to which this inquiry is directed. In the case,
I accept that the full court in NBMZ made that finding, but did they not make that finding solely on the basis, the slightly shaky basis, if I may add, with respect, that indefinite detention is inherently a human consequence?
No, Your Honour. Justice Buchanan made some reference to the human consequences of indefinite detention.
As did Chief Justice Alsop and Justice Katzman.
Chief Justice Alsop and Justice Katzman said that the Minister they're holding was 2 steps, which was at paragraph 9 of their judgment. They said that the Minister was not allowed, was not entitled, to exercise the Section 501 power blind to the consequences that would have within the framework of the Act.
And then at paragraph 23 and 24, they specifically state that they must be read in the context of the intensely human character of the Refugees Convention.
That's correct, Your Honour. In other words, what they also say is that that construction is bolstered. They say at a functional level, this is reinforced if the consequences are significant in human terms. It would be an impossible submission to say that the Migration Act required the Minister to prioritise the interests of the individual. It is a piece of legislation deliberately, overtly skewed against the interests of the individual. It provides that an unlawful non-citizen, as Mr Cotterill in consequence of the cancellation now is only entitled to remain in Australia if he can support it under some provision of the Act. Otherwise, he must be deported. If he can't, he must be detained. But the strength of their Honour's holding in that case is that the Minister had to consider the totality of those obligations. The regulatory purpose is discharged by the harmonious sequential operation of those provisions. What we're proposing the court do is confine or guide the extent or scope of one very broad discretionary power because of the operation of others in the same Act. This court has provided an example of that recently in the case of Plaintiff S4, where the court held that the Minister was not entitled to grant a temporary humanitarian visa which he may grant to a detainee irrespective of an application under Section 195A because of the existence of Section 46A, which was another discretionary power to decide to grant a particular type of visa. Now, the court held that by exercising the 195A power, the Minister precluded the applicant from potentially applying for a visa under that other provision, which he would otherwise be entitled to do.
But as your learned friends pointed out, that's a very different circumstance to that here, is it not?
In this circumstance, Your Honour, the court is doing something manifestly less strident than the court did there, though adopting the same constructional approach from Project Blue Sky, which is to consider the effect of surrounding provisions on the provision in dispute.
You're effectively just asking us to read the Act as a whole.
That's correct, Your Honour, but in an important respect. In that case, the Minister was actually restrained from exercising a discretionary power at all because of the legal consequences of that on another of his personal discretionary powers. In this case, we simply submit that the court should find that the Minister could not exercise Section 501 blind to such consequences of that as the Act gave rise to. In other words, he could have come to whatever decision he liked, but he was obliged to consider it, and the Act mandated that he did so.
Where do you draw the line?
You draw the line, Your Honour, when you can no longer find, when it's not possible to find in the subject matter, scope and purpose of the Act, a mandatory consideration. It would misunderstand our submission or the finding of the full court in NBMZ to say, as our learned friends attempted, that this involves some broad holding that personal circumstances, personal consequences of visa decisions are mandatory relevant considerations. Only such circumstances, such consequences, as the Act gave rise to and as responded to the purpose, the regulatory purpose of the Act, are mandatory considerations.
There are two possibilities. Once the visa is cancelled, you're either deported or you're held in detention.
That's correct, Your Honour.
You're focusing on the consequences, the practical consequences in this particular case as occurred in NBMZ in that case, of detention. But what about the consequences of deportation? They can be very serious for the individual concerned too, can they not?
Indeed, Your Honour. Detention and deportation have significant personal consequences.
So why isn't in every case the Minister then obliged to consider where deportation is an almost certainty or a certainty, what the personal consequences for the visa holder or the non-citizen will be?
The Minister is obliged to consider such personal circumstances as he or she may see fit. That's not the present inquiry. The reason for that is because Section 4, Subsection 3, the rest of the provision outlining the purpose of the Act, states that the Act is intended to be the only source of any right of non-citizens to enter or to remain in Australia. There is no other basis. And so the Minister is not required to turn his mind to some other individual concern, some other rights-based concern, some other personal impediment concern that might bear upon his decision. He may do so, but he's not bound. He is bound to consider such legal consequences relating to his other obligations of removal and detention and the regulatory purpose of the Act, which the Act caused.
But that,
Could you just articulate as crisply as you can what the consideration is that the Minister is obliged to take into account?
The legal consequence of indefinite detention as a prospect of the exercising the visa cancellation power under Section 501.
But there'd surely be some anterior inquiry about the likelihood of indefinite detention. Isn't that part of the relevant consideration?
No, Your Honour. We would, to that extent, adopt the reasoning on that point by the court in NBMZ and in the full court below. In the full court below, owing to the fact that it was a real possibility rather than a virtual certainty that Mr. Cotterill would be indefinitely detained. If the relevant consideration proceeds from the Act onto the factual circumstances, then the question of likelihood or possibility, as the court said, may bear upon the Minister's reasoning in other ways. He might decide to make a lesser provision for that prospect than he otherwise would have. He might decide to take different ameliorating steps than he otherwise would have, but he was bound to consider it. And to that extent, the court is not speculating what the decision may have been, not speculating how real that possibility is. It's simply saying that because that possibility is a consequence of the provisions of the Act which the Minister was operating under and within, that owing to the regulatory purpose, he was bound to consider it at some level.
so is your understanding of NBMZ limited insofar as it applies to consequences flowing from the same Act?
Yes, Your Honour.
Despite the fact that Justice Perry nearly 2 weeks ago in the decision of Roach explicitly applied the broader law of procedural fairness as a consequence that had to be considered by NBMZ.
This court would be entitled to adopt a similar approach if procedural unfairness was the ground review alleged. Procedural unfairness is not.
The ground of review alleged in Roach is the same as here. The Minister failed to take into account the relevant consideration. My suggestion to you is that a number of cases of the full court and the single judges of the federal court, Tanieli number 2, AUK 15, each of which have inched NBMZ further, which the proposition I'm putting to you arises from a fundamental flaw in NBMZ itself, that the definition of legal consequences has no limits.
No, Your Honour.
Why?
It does have limits because Their Honour said the Minister was not obliged to act blindly to such consequences as the Act gave rise to. If it is true, as Your Honour's question postulates, that formulation is being misapplied, that the court is contrary to the test which has already been established in Pico, Wallsend and Shawn Investments, that the relevant consideration comes from the Act and not from factual circumstances, then they are making errors of law. If they are applying NBMZ and saying that there are factual circumstances that look like that and not applying the relevant considerations test based on an understanding of the Act, they are making errors of law. To the extent that any clarification about that scope, about the scope of NBMZ might be required, this could be an opportunity. I suppose to that extent it's a good time to address the distinction on which my learned friends proposed to draw between NBMZ and this case. Given that in our formulation...
Can I interrupt to, in a sense, come back to a question I already asked you? You're in substance defending the decision of the full court.
That's
and
correct.
This issue was addressed, perhaps I'm able to say, most fulsomely by Justices Kenny and Perry. Paragraph 123, and it surprises me that no one seems particularly interested in referring to the decision the subject of appeal, but paragraph 123 of the joint judgment.
Yes, Your Honour.
They identify the relevant consideration as, and I quote, and this is in the second line, commencing the second line, the possibility that the appellant might suffer indefinite detention if his visa were cancelled is, however, a relevant consideration. Now, that isn't the way you put it, as I apprehend your submission. Is that right?
No, Your Honour. It's a reformulation of exactly the same relevant consideration. The relevant consideration is the legal consequence of indefinite detention as a prospect of exercising the visa cancellation power. Now, all of those elements are captured in the paragraph to which Your Honour has drawn attention. The possibility identifies the prospect of indefinite detention. The fact that it's irrelevant to the appellant's suffering, or the fact that it might be a consequence for him, is not the basis on which their Honours held that it was a relevant consideration, because as they go on to apply, this is because of the subject matter, scope and purpose of the Act. Your Honours, in the minute and a half or so that's remaining, the only basis on which my learned friends proposed to distinguish the case of NBMZ was that in Mr. Cotterill's case, it's a supposed practical rather than legal consequence of visa cancellation that sees him in indefinite detention. Your Honours, the court below noted that Justice Buchanan, in the case of NBMZ, Your Honours, if I may have a brief extension of 1 minute to conclude this.
Yeah.
In the case of NBMZ, Justice Buchanan drew no distinction between the two. He said that as both a practical and legal consequence of the Minister's decision. However, more problematically for the appellant's submission on this point, Mr. Cotterill's scenario is also a legal consequence. Section 198, subsection 2, requires his removal as soon as reasonably practicable. It is the conflict of that obligation with the fact that it is not, for the foreseeable future, reasonably practicable that leads to his detention. Impracticability is as much a legal consequence as the non-refoulement obligation in the case of a refugee. There are always factual circumstances which attract a legal obligation or a legal consequence. The non-refoulement obligation arises because there's a practical existence of a real risk of persecution if a person is to be returned to their country of origin. But the legal obligation arises under the Act, and it does so here. And on that basis, NBMZ was both correctly decided and applicable to the present matter, and the appeal should be dismissed.
Thank you, Mr. Peake. Is there any reply? We'll give it now. When you're ready.
Your Honours, I would like to reply to the submission of my learned friend that he made in regards to the conclusion reached about seriousness of the offending. My learned friend relied significantly on the provisions in the Minister's reasons surrounding the detailed factors given by Mr. Cotterill as to his version of events. Council would submit that by listing these factors, the Minister wasn't adopting a detailed approach as to how the circumstances of the offending, merely that by listing them he was stating that they were factors he would consider when making his overall decision. Council would reject that the Minister was obliged to make any decision on these factors as to whether or not he accepted or rejected them explicitly, and that by making that a requirement in this case, it's moving dangerously close to requiring the Minister to make a finding similar to a criminal court, that is being one whether or not the offending has actually occurred. Counsel for the appellant sticks to the submission that the section does not require express consideration of personal factors in order to find a decision that is legally reasonable, and that we rely still on the case of Hyun. Thus, in this case, Your Honours, we would conclude that on the objective facts available, the Minister was entitled to reach a legally reasonable decision that the offending was serious. If Your Honours don't have any questions, that would conclude my rebuttal.
Thank you. You have reserved a surplus. You may.
Your Honours, we content to waive our vote.
So there's a right to an extra
Yeah.
1.5 minutes from junior counsel for the appellant.
So, junior counsel for the appellant has 1.5 minutes up your sleeve. in the interest of fairness and reasonableness, I'll offer that to you. You don't have to take it.
I would very much like to. Thank you, Your Honour.
Very well.
My learned friend takes the leap from describing in very eloquent terms how indefinite detention arises under the Act, and then focuses in on section 501 and reads it into that section that the Minister is required to take it into account. Respectfully, that overburdens the Minister's responsibility under section 501, which is focused on character, and asks the Minister to prematurely consider the consequences of his actions. And to what end? If the Minister is required to consider indefinite detention, the end game of the respondent is surely only to make the Minister more inclined to consider indefinite detention as something that would push him towards granting a visa. But granting a visa to an applicant who marginally fails the character test conflicts with the national interest. Respectfully, Council would submit that any impediment to the ability to remove an entrant into Australia does not arise as a consideration under section 501, because that section is exclusively focused on character. And so the consequences flow naturally, and the next step is to consider whether, if indefinite detention is a problem, what the next best alternative is. And it may be to make a residence determination, or it may be to explore other alternatives. But to require the Minister to prematurely consider indefinite detention at section 501 would create all the problems of distortion and negative detrimental incentives, which I referred to in my main submissions. The last point which I'd like to make, thank you, Your Honour, that concludes the case. Thank you.
Well, that concludes the oral submissions for this afternoon. We will obviously reserve